Hello, everybody, and welcome to our Friday Live. I'm Amanda Farmer. We are here on the Your Strata Property Facebook page and also heading out to LinkedIn. Hello, how are you? I want to say Happy New Year as well. This is my first live chat since the beginning of the year, first live for 2021. How was your festive season? Have you had some time off? I know many of you, Strata lawyers, Strata managers, were taking most of this month of January off. We had our Australia Day public holiday fall at a rather convenient time. So I got a lot of out of office emails from colleagues this week saying that they were enjoying the extra week's holiday. Kids back to school. We went back to school yesterday. So feeling like we're getting back to normal, if you like. Parents out there will know what I mean. A little bit of good stuff to look forward to here for 2021. Lots happening, and we're going to be sharing that all with you here on the Your Strata Property Facebook page and the podcast as well. Though I haven't been live, we have had a few podcast episodes go out already this year. A couple of chats with Rena, our popular one this week. Have a few comments there on this week's podcast episode and in my inbox. Lots of people enjoying that one and giving us some feedback about those fire doors, the famous fire doors that may or may not contain asbestos. If you haven't listened to podcast episode 249, you may want to check that out and let me know your views. You can access that over at yourstrataproperty.com.au/podcasts. But as I have posted here on this page, on LinkedIn, over on Twitter, I have been doing something a little different this week. I have been participating in the Community Associations Institute 2021 virtual law seminar. Now, if you're not familiar with the CAI, that is the American equivalent of our SCA, if you like. It is the organization that looks after community associations and community managers, what we might call strata managers over in the US. And they do have a division for Community Association Lawyers, the College of Community Association Lawyers, or CCAL. And they have an annual conference over in the US, and just as we do here for our Australian College of Strata Lawyers. And I have been very proud to be representing our Australian College by attending the conference this year online. It is being held on Eastern Time. And lucky for me, it is a half-day event held over 5 days this week. And it means that I tune in at 3 a.m. and we finish up by 7 a.m. and I get on with my day. So if I'm looking a little tired, I can see the bags under the eyes there at this time of the day starting to come through. It's because I've had 2:30 a.m. wake-ups for most of this week. I had to double check, actually. I was all set to tune in from Monday morning. And then I realized that 11 a.m. Monday Eastern Time is actually Tuesday morning here in Sydney. So I didn't make that mistake of getting up a day early. It was close though. And tomorrow, Saturday morning, will be the last session for the week. So a big thanks to the Australian College of Strata Lawyers for facilitating my attendance. It was planned that if it was happening in person, that I would head over to Palm Springs. It was going to be held in for 2021. Didn't happen this year. They shifted the whole shebang online, and they're doing a fantastic job. I mean, you don't really expect anything less from the US, do you? They know how to put on a good show. They've got all the tech worked out. There are over 730 lawyers attending this conference, and they are specialist community association lawyers. That is just huge. To give you a comparison, we usually at our conferences, which are very well attended, our Strata Lawyer conferences, annual conferences that we have, we get 70, 80 is a really great turnout for us lawyers attending right from across Australia and New Zealand, and not quite the 700 plus that they have in the US. So that alone, just the scale of their profession is quite amazing. I'm seeing a number of you come through now and say hello to me. Lovely to see you. If you are tuning in, feel free to drop me a hello in the comments. I would love to say Happy New Year to you. Just as Sean is saying Happy New Year to me. Hey, Sean, lovely to see you for 2021. Emiliana is here. Hi, Emiliana. I would like to share with you this afternoon some insights, as I've said in the title here, some lessons and some laughs that I've had this week attending the Lawyers Conference over in the US. This conference draws community association specialist lawyers from across the nation there, from representatives from all of the 50 states, as far as I can see, from Hawaii, Wisconsin, Philadelphia, Florida, right around the country. We've got time to do some networking as well early in the mornings, early for me anyway, which is really awesome to be able to chat to these lawyers, to compare how things are going over there compared with how they're going here from the practice perspective. So we were talking in one of the networking sessions, it was a breakout session for litigators, and I attended that one, and we were talking about how we are now running our court hearings, our attendances online virtually, whether it's by phone or, interestingly, in the US by Zoom. Their courts, and they have from trial courts to appellate courts, small claims divisions, all different levels, similar to what we have here. They are running their hearings by Zoom and doing really, really well with that. The interesting thing, and I spoke about this in the breakout session with them, we don't use Zoom here. Our courts, as far as I'm aware, anyone can let me know if I'm wrong, but in my experience, our courts are not actually using Zoom. They're using either their own government software, or they may be using some Microsoft software. But Zoom just works. It works so much better in my experience to some of the other systems. So I was a little bit jealous that our US counterparts were able to enjoy the pleasure, the privilege that is Zoom, and doing things like mediations where they can run PowerPoints and show slides and photographs and videos to explain to other parties, to the mediator, and I imagine in hearings to the judge, an insight into their client's case. So getting really creative using that technology, which is great. I can see a cheers there from Sean. It is Friday. It's Friday afternoon. If you are having a drink, look, I'm not, because I find it really hard to get up at 2:30 in the morning if I've had a drink or two the night before. I've got to that midlife stage where if you have a drink, you kind of don't sleep very well. It's really sad. So no, I am abstaining for the week, which is not a bad thing for anybody. Now, when I first joined in the conference, Tuesday morning here it was, Monday over there, as I said, 700 plus lawyers jumping onto the opening session. And I was very lucky to get a very personalized welcome, a shout out from Tom Skiba, who is with the Community Associations Institute there in the management team. And he gave me a special welcome, Amanda Farmer, all the way from Sydney, Australia, tuning in where it is 3 a.m. there. So I got a lot of wows and congratulations and thank you. And I can't believe you are not in your pajamas, Amanda, and you're here. And I said, well, I'm not in my pajamas from here up, but you don't need to know what's going on here. It was wonderful to have that really warm welcome, and for people to post in the chat about their friends that they have in Australia, and to say we're so lucky with our weather at the moment, that it's a beautiful summertime, it's snowing in so many places over there, and how well we are doing in this pandemic. So we have quite a good reputation, as you would hope, over there, that our numbers are so great and that our lives really are just so different to what they're experiencing, of course, over in the US at the moment. So lots of attendees saying, we want to have our conference in 2022 in Australia. We want to head over to Sydney. We're moving there. We've got family that live there and we're coming over to stay. I went scuba diving there. I love the Barrier Reef, all of that stuff. So we're representing, they definitely know where we are and all of the good stuff that we have to offer. So lots and lots of compliments there for Australia. The keynote session kicked off on Tuesday morning with a keynote from Leon Legothetes. I hope I'm saying his name correctly. You may have heard from him because I understand that he has a Netflix show. He is a global adventurer, a philanthropist, and the best-selling author, creator of the book and now Netflix show, The Kindness Diaries. And he travels the world delivering his message that everybody should just be kind. Be kind to each other. He's a former stockbroker, sharing his approach to success and survival in these difficult times. And his message really resonated so much with everybody present at this time, when in the US, everybody just needs to remember to be kind to each other. And his keynote was really, really well received. We then got into some nitty gritty, talked about some cases, a case law update. We've had a couple of those, particular to some of the cases that have been discussed, some of the issues that are facing our US counterparts, and unsurprisingly, not so different to what we are facing here. Yes, they are talking about short-term letting over there. They are talking about pets. They're talking about smoking. They're talking about difficult behavior, residents behaving badly, and how we sort that out, how that becomes complex when we might be dealing with residents who have a mental illness. There was a session on that this morning that I found really, really enlightening. They're talking about discrimination. They're talking about aging in place. All of these issues really are far-reaching worldwide issues that we're facing in our communities. So we have so much that we can share and so much that we can learn from each other. I have to say, if you ask me to make an overarching sort of assessment perhaps of where we are different, I'd have to say what's standing out to me at the moment is that there is a lot more independence, let's say, in the communities over in the US. They have the ability, far more so than we do, to create their own rules, their own bylaws, and they have far less restrictions and restraints on how they go about doing that. They have definitely a sense, more so than we do, of individualism, of running their show the way that they want to run it. They're not as bound by legislation as we are. And that is good for some communities who are able to set up the communities the way that they like. For others, it creates, you can see, some difficulties, some questions, a lot of work for lawyers trying to understand what's legal, what's not, and a lot of litigation, because they don't necessarily have the boundaries that we have with our legislation. There are a few issues coming up, and I think, well, we've got legislation that says that you can't do that, or that you can do that, that regulates that particular issue. And in the US, where they don't have that, they're having to litigate to get that answer. A lot of cases about interpreting what particular bylaws or what particular rules mean. A lot of cases about whether communities have standing to bring cases before the courts, whether they have standing to represent lot owners in a particular cause of action. Our legislation really covers that off, I think, in all of our jurisdictions. It's a lot more detailed. We might complain about that, but I think that also reflects the broader cultural difference, perhaps historical differences that we have in our two countries. So that's my broad assessment after a few days of immersing myself in US community law, community association law, homeowners associations. They call some of their communities are called homeowner associations, which they then call HOAs. The HOAs when they're referring to their community. So trying to keep up with that terminology. I am seeing a hello here in the comments from Henry. Good afternoon, Amanda, from down the road this time, stuck in Sydney due to border issues. Oh, interesting, Henry. Well, enjoy our lovely city while you are here. It's good to have you. You can stay as long as you like. If you are coming in and want to say hello, please do. Love to say hello to you and a happy new year. A couple of the cases when we were going through the case law updates over the last few days that jumped out to me that I wanted to share with you guys and perhaps get your thoughts and your comments, whether you think this is surprising or interesting. One case about what they call assessments, which we would call levies. And these are very recent cases that the lawyers are summarizing for the audience that have come up over 2020. In this particular case, owners sued their homeowners association because they were saying they shouldn't have to pay levies, assessments, for facilities that they're not using. So this is something that we've heard, haven't we, Strata managers, come up while our pools and our gyms are closed during the pandemic. We've all had a neighbor, a client, a committee member, a resident say, well, hang on, if the pool's closed, if the gym's closed, why am I still paying levies for these facilities? Shouldn't I get a break because I'm not getting the benefit of the facility? Well, absolutely. This has come up in the US in a really interesting case where the community was governed by what the lawyers called a deed. They didn't have the direct legislation that was governing this community or bylaws. It was a community that was set up pursuant to a document, a deed, and the rules for the community were in the deed. And guess what it said in the deed? The payment of assessments is conditional on the use of specific common facilities. So what the court had to do was interpret the deed. They read that clause in the deed that was governing this community and said, well, if the deed says that, then yes, you only have to pay your assessments if you're using the facilities. And I tell you what, the lawyers were shocked at this result and quite up in arms about it because they said, if this stands, there will be absolute chaos in a number of our communities that may have similar terms in their deeds. And my understanding is that this case is under appeal. And you can imagine the kind of chaos it would create if you had to go around and work out who was actually using the pool, who was actually using the gym. Do they then have to pay for that use? How much should they pay? And who gets a break because they're not using it? There'd be a full-time job in there for a strata manager just doing that. So that one definitely caught my attention. Another case where a community had a bylaw that said if the residents, the owners, were to take action against the developer for defects litigation, 51% of the owners had to support that action in a meeting. And before the litigation could be commenced. And in this case, the owners had not had that meeting, had not passed that resolution to commence the action, but they had started it anyway. So they'd commenced it in breach of their bylaw. The developer noticed this and said, no, this litigation cannot continue. They have not complied with the bylaw. They don't have authority to commence the action. And that was notwithstanding every single owner, except the developer, who was one owner, every single owner supported the commencement of the litigation. And ultimately, the court said that they wouldn't accept that the litigation had to be thrown out just because there hadn't been this procedural compliance with the bylaws, because to do so would be a violation of public policy. So that was a big relief there for the owners who could continue their litigation against the developer, even though they didn't have the resolution before they commenced. They did go back later and get that resolution. This is one of the examples where I was sitting there and thinking, we have legislation, at least in New South Wales, that says, yes, you do need approval to commence legal proceedings and approval to to incur a certain amount of legal costs, but our legislation says if you don't have that approval, it doesn't affect the validity of the proceedings, okay? And that's come about because we've had a couple of these cases in the past in New South Wales where the validity of proceedings have been challenged because there wasn't the correct approval. So we have then put into our legislation what the position is should that happen again, so that we can avoid these kinds of litigious arguments. And I'll say here, you think it's tricky with the few states and territories that we have here in Australia with our different strata laws. 50 states over there, guys, and the laws are all quite different. I was asking a couple of questions in the Zoom chat about particular things, surprised at certain outcomes. And I asked, is this common? Is this usual? And I had many lawyers reply to me and say, Amanda, it depends on the state. The laws really vary across states. The practices vary, and lawyers are doing quite different work in one state to what they might be doing in another, which is interesting. But they are all incredibly adept at understanding what's going on around the country. That must be a burden in itself, and the presentations definitely cover lots of cases from all the different jurisdictions, which is great. I'm just heading over to our chat here. Sean was having trouble with the transmission here, but I think you've worked it out. Nice to see you, Petra, saying good afternoon. Hi, Michael, nice to see you. Sean, yes, it was Telstra NBN. Yes, well, I hope I'm coming through clear. I've hardwired. I've got my 10-meter long cable happening here. So I hope that's all working for everybody. What else? Well, definitely they are dealing with issues when it comes to smoking and smoke drift, another popular one for us last year with everybody at home. There was a case involving a cancer survivor and an asthma sufferer who said that the smoking that was going on in her community was a nuisance and she wanted it to stop, wanted the court to intervene in that. The community actually wanted to support her and proposed an amendment to their bylaws to prohibit smoking. That amendment did not pass. And although she went on to challenge that decision, the court ultimately found that in that particular community, to limit smoking within units would be unreasonable. And my memory is that in this building, they had bylaws that said we can't make unreasonable rules. So very interesting, quite different to what our courts are saying here in New South Wales, at least, when it comes to smoking and it causing a nuisance, and our courts and tribunals being able to make orders that prevent people from smoking in their own home or in certain parts of their home. There was, if you can imagine, while we're all on these Zoom presentations, it's a very large group, but there's a lot of chat happening in the Zoom chat window, and it's very interesting to watch that and see some really practical experience coming through from the lawyers. And a couple of the lawyers were posting that smoking complaints have increased in some states recently due to the legalizing of marijuana. So we're not just talking about cigarettes necessarily in some states. Some other clever lawyers, of course, then posted, well, you don't just have to smoke it. There are other ways to ingest it, so that doesn't necessarily have to be a problem. That started off a lot of interesting banter, which is all part of the fun. Another case, issue that is close to our hearts here in New South Wales about pet ownership. Again, as I said earlier, really each community is able to decide on its own terms for its own community what they do about pets in the US, aside from, of course, assistance animals, which they call emotional support animals. They don't, as I understand it, have any overarching legislation necessarily about animals in apartments like we do in some of our strata legislation and proposed here in New South Wales to deal directly with animals. There was a case where the bylaws in the particular community said that the keeping of an animal was a privilege. not a right. So when the dog became aggressive and attacked some other owners, that privilege was revoked. And when it was challenged, the court looked to the terms of the bylaws, said, no, the keeping of animals is a privilege. That privilege has been abused. You have an aggressive dog and the dog has to go. So interesting one there, and a good place for me to chime in and let our American counterparts know what was going on here in Australia when it came to the keeping of animals. The Cooper decision from our New South Wales Court of Appeal has in fact said the opposite, that a bylaw that bans the keeping of animals is interfering unreasonably with a property right. So we have used that kind of language in our cases about pets here in New South Wales, very different to it being otherwise a privilege. A whole session about electronic meetings, which was really interesting. Very similar issues to what we are facing and very similar benefits to what we're all enjoying here when it comes to electronic meetings. Interesting that, as I understand it, in most states, there was no legislation that permitted electronic meetings before they had their emergency COVID legislation. Maybe a couple of states did have that, but most did not. And the lawyers were saying that so many of their clients, their homeowner associations, were conducting meetings. They just went online when the pandemic hit, and they were doing so blatantly in breach of their legislation, in breach of their governing documents, because they just didn't have these provisions that we have had for some time in New South Wales and Queensland to be able to have electronic meetings otherwise than in person. All the lawyers were definitely saying how much they enjoy the shift over to the electronic format. The engagement is what they pointed out. There was a poll during the session. What's the real benefit here? They found that it's the engagement of the owners, the increased participation in meetings, more people being able to have a say because they have access, more ease of access to their meetings. And I think that's something we've talked about here a number of times. That is one of the real benefits. And at the moment, because they've only got these powers through their emergency legislation, there's a lot of lobbying going on, and the lawyers are behind this push to enshrine this ability to have electronic meetings into whatever the applicable legislation is in the particular state, to make sure that they can, even when the pandemic's over and these emergency powers and emergency legislation is no longer in place, they can continue to have their electronic meetings otherwise than in person, because it's just or at least have the option to continue doing that, which of course makes a lot of sense, and that's something that we will all be continuing to do, more so even on the other side of this. Another hello there from Pamela. Nice to see you. Lovely to have you joining us. More of you coming in now. Feel free to drop me a hello. Nice to see you here for 2021. Now, there was a little bit of talk about vaccinations, a query about the impact of a rule that may say, and this, we hadn't seen this yet, or the Americans hadn't seen this yet, but they're waiting for it. A community may make a bylaw that says if you are not vaccinated against COVID, you cannot use the pool. You cannot use the gym. Query whether that would be discriminatory. And there is some proposed legislation, I think, in a number of states to deal with that. And no particular position taken yet, but that's one that had been flagged as a concern from the legal side, that we may start to see bylaws about that and may not know whether they are legal or not. Apparently there is legislation or a proposal, I've marked it down as a proposal in Georgia and in some other states, to use homeowner association clubhouses to vaccinate en masse. So set them up as vaccination clinics. And these are clubhouses, I understand them to be perhaps in over 55s developments, retirees, holiday places, and there's a real concern amongst those communities about exposure, about liability, where we are vaccinating on the common property, on the community property. What does that mean if things go wrong? This is an uncertain procedure, some feel. And is there going to be some liability on the community if they permit vaccinations to take place on their property. These issues that are having to be dealt with over there, so different to what we may be facing here. This question of liability, of exposure, concern about getting sued, if I can put it that way, is a big deal. It's a big deal over there, more so than it is here. And, some of you will understand that. They do have a high threshold when it comes to payouts for civil liability claims. They don't have the cap that we have here in Australia. We have a cap on civil liability where you don't see multi-million-dollar payouts when someone is successfully sued. So being sued, homeowner associations, community associations are very worried about being sued and making sure that they have insurances in place. That was really at the forefront of concerns in 2020 when the pandemic broke. Very concerned that owners would start suing their community associations if the community did not properly deal with, have a proper response to COVID, and if there was some loss suffered, illness, even to the extent of reduced immunity. If someone has had COVID and then comes with a reduced immunity, is there going to be some exposure on the part of the community association who should have done something differently, perhaps should have closed the pool, should have closed the gym, and if they had, then this person wouldn't have suffered the disease. Real concerns there about that happening down the track as well, that communities would be sued, and legislation. And maybe I'm out of the loop, but I'm not sure that I have seen this here. Someone will tell me in the chat if I've missed it. Legislation that limits the liability of certain organizations, which has been broad enough to include community associations, limit their liability where there is some COVID-related damage or loss. And it was quite of a lot of interest for the lawyers to understand in which states that legislation was in place and protecting their community associations and their board of governors, board of directors, similar to our Strata committees, where that legislation was in place and where it was protecting them should there be some claims arising from COVID. It was one of the examples given was a couple of slip and fall cases. So somebody had been in the common area, there's a slippery floor, it's wet, they fall over, they break their leg, the resident goes off to hospital or is even in rehab and contracts COVID while in hospital and rehab. The question that arises is, but for the wet floor that the community association left there and should have cleaned up, this person would not have fallen. If they had not fallen, they wouldn't have gone to hospital. If they didn't have to go to hospital, they wouldn't have got COVID. So is it then the community association's fault that this person has contracted COVID and then has the loss, the damage, the illness, the injury that arises out of the disease itself? Really interesting questions there. Those cases are before the courts in the US. We have been so lucky here that we just haven't had to think about those issues, but they're definitely at the forefront of the community associations lawyers' minds there in the US. While I'm on the COVID topic, just this morning, in quite a fun panel, which they call the Panel of Pundits, that was happening this morning, a panel of 5 lawyers, just giving some day-to-day practical stories, experience, some guidance about how their year has been. One of the lawyers said that they were involved in a case before the Small Claims Court. It was what they call a collections case. So this is someone who hasn't paid their levies. We might call it a levy recovery or a debt recovery. And the case was due to be heard on a Monday. And on Friday afternoon, the lawyers saw on their answering machine there was a message, and they listened to the message, and it was the defendant who owed the money, and the lawyer was acting for the homeowner association. And the defendant left a message saying, "Oh, I won't be able to come to the hearing on Monday. I'm going to seek an adjournment because I've been unwell and I have just gone to the doctor and I've got my test result and I have COVID." And the lawyers listened to that and thought, okay, well, that's a good excuse. Fair enough. I guess they'll get their adjournment. The message went on to say, and I've got a check for part payment of the debt and I'm just coming by your office to drop it off. Now, the lawyers had no way of contacting this person. I think they tried to ring them back, didn't get through. They're in the office. It's Friday afternoon. This person who has just tested positive is on their way to the office to drop off a check. What they ended up doing was locking the doors, waiting for this person to arrive. And they had a glass-fronted office, and they were able to sort of sign language through the door that they were not letting this person in. I think they the person slid the check under the door, and the assistant sprayed it, sanitized it, and they were able to deal with it that way. But terrifying, okay, terrifying. Just a different world out there, and definitely, we can see on the screen when we're tuning in people in offices wearing masks, and very different to what we're experiencing here. And as I said earlier, if you're tuning in now, I did say earlier we were getting a lot of compliments here in Australia for how we've been able to handle this pandemic, and lots of wishes to come and join us here in our lucky country. Okay, so they are really my highlights so far, highlights issues from the 2021 Community Associations Institute virtual law seminar. Last session tomorrow up at 3 a.m. to continue enjoying that. If anybody has any comments or any questions, particular questions about how things may operate over there, feel free to pop them in the chat here or later on, and I will come back and check them out. I've just given you there my brief summary on what's caught my attention while I've been tuning in. But I do, having heard those points now, I do come back to what I said earlier about the overarching difference, I think, is that communities really are able to, left to, allowed to make their own way in the US, more so than our communities are here. They're not as bound by legislation. They have broader and more extensive powers to make their own rules, and to set their own agendas, if you like. And remember that we're dealing with much, much larger communities over there in a lot of cases. Very much that individualistic notion in the US, which I think in my view, demonstrates our real, or is symptomatic perhaps of our real cultural differences that we have and that we see play out. Whereas here in Australia, we are much more bound, we much more have our rules enshrined in our legislation, and we're kind of okay with that. I think we're okay with that. Let me know if you don't agree. From the lawyer's perspective, I think it makes things a little bit more straightforward in a lot of ways. But having said that, we have our own problems with our different pieces of legislation, that's for sure, and New South Wales in particular, going through a process now, just in the next couple of months, of reviewing our New South Wales strata legislation. I was on a call with some of my colleagues, lawyer colleagues. We are putting together, on behalf of the Australian College of Strata Lawyers, a submission to the New South Wales government on the discussion paper for the New South Wales strata law review. And I think we might be up to about 60 line items identifying particular sections that we think need some review, need some change, need some amendment, and putting submissions to each of those is going to be a big job. But there's lots there that we can definitely improve. Michael is asking a question here in the comments. Is the system similar in the US? Notice to comply, mediation, low-cost tribunal, etc. I'm not sure of the answer to that, Michael. I think yes, because we are talking a lot about, a lot of the lawyers are talking about the mediation process, and there's even some mediators tuning in. So I think absolutely they do have the mediation process. They have what they call small claims court, which may be their version of low cost. There's no mention of a tribunal. I don't think they have the specialist tribunal like we do here in our states, our NCAT, our VCAT, our SAT, our QCAT. I don't think they have those specialist tribunals. It's more courts, but certainly mediation is popular there. I'm not sure if it's a mandatory prerequisite as it is here in some cases. Good question. Okay, now I am going to send you out into the world for your weekend. It's not even my dinner time, it's past my dinner time. This is my cup of tea and a biscuit time before I tuck myself up into bed to be up for a 2:30 a.m., my last 2:30 a.m. of the week. So has been very soon. I will be over to the US to visit some of these communities in person. Would be amazing, and to meet a lot of the great lawyers and good friends that I'm making through this conference. So very, very proud to be there representing our Australian College of Strata lawyers. All right, guys, have a fab weekend. It's lovely to be here with you live after about a month or so off. I try to be live in this long format every couple of weeks. So 2 weeks time, tune in for our Friday live. And until then, enjoy this crazy world that is strata and apartment living. Good luck. Bye, everyone.